Hello?
I think, can you see my screen? I think it's swapped.
I'm sorry? Hello?
Yes, I
Hello?
see your screen.
Okay. Yeah, I got a few more people to let in here. Let me double check.
Yeah.
Okay. All right. We are about to get started and oops, wrong one. There it goes. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of Wills and Advanced Legal Planning and Why Do You Need It? My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included, we have the City of Houston's Department of Neighborhoods and Lone Star Legal Aid. And on behalf of that presenting partner, today we have presenting Ms. Jessie Campbell, who's going to be providing you with all the information. But to introduce our other partners, we also have, um, oh my God, I'm looking at the screen and still can't. It just completely lost train of thought. But the Harris Central Appraisal District, the Harris County Tax Assessor Collector's Office, the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, and now also the Harris County Attorney's Office, who are all make up A Month of Service. And A Month of Service is the collaboration of all of our organizations coming together on a monthly basis and offering a variety of different workshops, resources, information to the community that do not have access to available resources or don't know about available resources that they can actually tap into. And several years ago, we decided to collaborate and come together and pool a lot of our initiatives and create a larger impact to get as much information out to the community as we possibly can. We used to be in person during these particular kind of sessions, but of course, due to COVID, we transitioned to the virtual platform. But sometime throughout the year, we're going to try to slowly get back into the in-person and online Zoom. So, but we have this presentation, the Wills and Advanced Legal Planning. This is part one. There is a part two of this session, and Jesse's going to go into the details about what part two is. But again, there are a variety of different workshops that we offer throughout the year. And this one is kind of the kind of the preemptive, the planning, what happens before. Next Thursday, which is the second Thursday of each month, we have the what happens after someone passes. And that one's going to be the clearing title for inherited property and probate concerns. So so if you want, please tune in for that one as well. And that one kind of goes through explaining the process of what probate is like and basically what happens if someone passes and they don't have any of this stuff put in place. So that kind of gives you a little bit better understanding of what happens before and what happens after. But again, we wanted to make sure that we try to get as much accurate and up-to-date information out to the community as we possibly can. We know that a lot of folks kind of, you know, I call them the street committee. They listen to the street committee that kind of tells them about, you know, what they did, what happened, and you should do this and do that. And they rely on the TikTok and, you know, all other kind of social media and whatever to kind of tell them certain things that are not necessarily applicable to the state of Texas. So regardless of where you're joining us from, whether you're you know in different counties, but the information that does get presented here is relative to the entire state of Texas itself. So if you have property that's in another state or have assets and things that are in another state, we can only tell you what's applicable for Texas in this presentation. So this is your opportunity to ask questions. Please feel free to type your questions into the chat. You also have the opportunity at the end to unmute yourself and ask your questions directly if you are not sure about how the chat works or what have you. And but we do record the session in case you heard that when you came into the room. We do record the session and send it out to folks that have registered in case they want to go back to review it and to share it with other people and then we also broadcast live on our social media platform. So we do want to try to protect your privacy as best as we can. So we ask that you try to keep your questions very general. This isn't a client, you know, attorney privilege moment here. So be careful about the information that gets kind of put out there for everybody to have access to. And plus, We don't want to get into real specific information. We do encourage you to reach out to our legal service partners like Lone Star Legal Aid for more one-on-one questions about your specific information. So this basically kind of really isn't the platform to get into a whole lot of detail about your personal situation. So try to keep your questions to be as broad and as general as you possibly can. So again, we want to try to protect your privacy as best we can. There's a lot of information that's going to be covered here today. There's a lot of different documents. Each one of the documents that she does go over that make up an estate plan, I do have copies of the templates. I will be sending those copies out. I don't send them out in advance for the purpose of we want to make sure that you kind of focus on what she's actually saying as opposed to looking at a lot of documents and trying to, do things or look and follow along at the same time because it's again a lot of information. You do have the opportunity to come back to these sessions as many times as you'd like. In case there's something next month that you decide, oh hey, I forgot about this question, what have you. You do have the opportunity to do that too. All of our sessions are free. And again, we do encourage you to, bring your family members and have them come in and listen, go back and watch the recording, sit around for Sunday dinner and have these conversations. It's unfortunate that a lot of communities don't have these kinds of conversations anymore. And it's, unfortunately, they kind of wait until it's too late after someone has already passed to sit and kind of talk about this. We know that, folks, they get a little, what's the word? Superstitious when it comes to talking about this kind of thing, and thinking that it's going to make something happen. And that, if COVID taught nobody anything else, you don't know what's going to happen at any time, and we don't have numbers, we don't have tags. It can happen to anybody at any time. You could become disabled, you could, lose your job, you could, you know, plane could fall out of the sky, whatever could happen at any time, and we just don't know. So we want to make sure that you are properly prepared to put some things in place that could help with preserving your generational wealth and your assets and making sure that your family is cared for. So this is having an estate plan or having this thing in place could be one of the best gifts you can actually give your family members because there's nothing like trying to grieve and handle all of this kinds of stuff at the same time, and that stress and that anxiety, it gets to be very overwhelming, and trust me, I know, been there, done that. So with that being said, we want to thank y'all for joining us this afternoon. We do hope that you receive all the information that you intended when you registered for this workshop. Again, there's a lot of information that's going to be covered. We're here to help. We're here to answer those questions, and we're going to go ahead and get started. So, Miss Jessie, we're going to have you introduce yourself, and we're going to move right on into our presentation. And you're on mute.
Okay, all right.
Okay.
Thank you, everybody. And let me go ahead and get everything shared and all situated so I can answer your questions. So thank you, Ms. Nia, for the introduction. So my name is Jessie Campbell. I am a directing attorney with Lone Star Legal Aid. Thank you so much for joining us today for this discussion on legal advance planning and why you need it.
Your voice is a little light, Jessie.
I am
Okay,
so used to having a big microphone that
okay,
picks me
now
up. So let me speak
that
up a little bit more.
okay, that's better. That's better.
Yeah. So first, let me talk a little bit more about who we are. So Lone Star Legal Aid is a civil legal aid organization. We provide free legal services to low-income households. We serve 72 counties in the eastern and Gulf Coast regions of Texas and 4 counties in Southwest Arkansas. So basically, we go from Texarkana down to Galveston, and from Louisiana to about Waco is about how far west we go. We actually, I need to update that. We have 11 offices, including our Houston headquarters. And so we just recently closed a few offices in the area. And we serve financially eligible clients based on the size of the household, income, and assets. I wish I can give you numbers on what that means, but it's actually pretty complicated math that we have to do to figure out who's eligible. But don't assume that you may or may not be eligible. The estimates are about a third of the state may qualify for services depending on on it. So there is a possibility that you may qualify. And so, it's just an application process. The law types that we serve are varied and it's civil. So it includes consumer, employment, family, housing, landlord, tenant, neighborhood problems, education, public benefits, estate planning, and probate, just to name a few. And that is our contact information. Don't worry, you don't have to hurry to write any of this down. All that information will be shared with you in an email afterwards, and then I'll have it at the end as well. Um, and so disclaimer of purposes. Today's is for educational purposes only. As Ms. Nia already mentioned, this is not legal advice, and please do not take it as legal advice. This is me trying to give you as much legal information as I possibly can, and it's kind of at a broad level. It's trying to kind of give you the big information as best as I can, so that way when you do go seek legal advice, you can kind of have an idea of how to talk to an attorney about your situation, and then to be able to kind of ask questions, so that way you can kind of get a sense of what you need to do and what types of questions you need to ask, and so that you can kind of move forward on that. But as you also kind of start asking questions, be aware I cannot give you legal advice today. I'm not creating an attorney-client relationship with you today. I cannot do that. This is also a very public space, even though for those of you who may be on the Zoom call with me today, this is being streamed. This is live on social media. It's on Facebook. It's also being streamed on YouTube, and it's being recorded. So not only is once the live stream ends, people will be able to come and watch this later on. And I do not want you sharing any of your personal information anywhere, so that people can come and find out more about you and maybe be able to take that information and do things with it that can be harmful to you down the line. And people can take that private information, steal it, and do identity theft, do all sorts of things, right? So one, we don't want you asking information, sharing information about yourself that people can do things with it. So please don't do that. So one, I can't answer your question to give you legal advice anyway, so don't ask it. And two, we don't want you to get potentially be harmed by these questions by other people down the line. So be aware of that when you are asking these questions. So be as we kind of think about that. Right. One of the things about this area of the law is that it is pretty complicated. This is, while it is something that a lot of people think about and talk about, and there is, as Mia says, there's a street committee, and a lot of people can kind of share this information. It is complicated and it's personal. It is one of the only areas of the law that touches everybody. Every single person in this country, in this state, will eventually, at some point in time in their life, be touched by the law as it relates to estate planning and probate, because every single person will eventually pass away or will have a loved one pass away. And so it is one of those things that we all have to plan for and prepare for. And so it is so we try really hard to educate people so that they are prepared for it, and that they're not dealing with it during the time of grieving and during the time of potential crisis, and preparing for something during a time where someone has become incapacitated. And we're going to talk about all these terms and what they mean and how we're kind of dealing with that during a time of incapacity and during a time when a person has actually passed. And so and there's a lot of misconceptions and misunderstanding around it, because a lot of people talk about it. I mean, you hear about it on TikToks for those of us who are young and are on the TikToks. I'm not young, but I am on a TikToks, and I see a lot of, and I get so frustrated because I see lawyers on TikTok being like, if I was I will tell people, it's like, oh, if I was to tell my clients, I would tell you not to do that. I'm like, oh my gosh, how irresponsible of a lawyer being on TikTok going out and be like, this is what I would tell people to do, because in their state, this is what they would tell people to do. And it's like, well, how can you go onto a platform that is an international platform, and say this is what you should be doing, when it's not going to be true in every state and for every client, not for every individual, right? And then you have national platforms such as like the Today Show or Good Morning America, CNBC, whatever program you would be watching, where they're talking about generalities, like this is what we think you should be doing, right? Because big picture, big kind of thought process, like, right, may also be true. That's what I'm going to be doing today, right? I'm going to be talking about big picture thought processes, like, right, like, oh, this is the big things that we should be thinking about, right? And so I'm going to be doing the same thing for you today, right? And, it's like, this is how everybody should be thinking about it. And that's why it's really important that we think about it in the sense of like, I'm going to give you the broad strokes, like, right? I am also a street committee today, right? I'm going to also be thinking about. So think about it, like, as you hear things, be like, okay, I understand what Miss Jessie is saying. I hear what she's saying, and it may or may not be true for you. But I am going to give you some general principles where I'm going to say everybody needs this. And when I say that, it's going to be true. It's going to be say that even though that it may sound like, well, I don't think I'm going to need that. There's going to be some generalities that are going to be minimum protections. These are the things that everyone's going to need that you hope you may not actually apply at some point in time. But if you don't have it, it can be damaging not to have. And it's better to have something and not need it, and it never applies because you're going to do something that's specific to your individual needs. You're still going to do the document that you need that fits your specific needs, but you're going to go ahead and do something that kind of gives you that minimum protection. So that way, if something does happen in the meantime, you got something in place that can kind of always be sure that you're secure. You have the knowledge knowing that until I get something in place that does meet my specific needs, or when the specific needs come about, I got something I need, right? So kind of keep that in mind as we kind of go forward as we're kind of looking forward, like, okay, now I understand why we need some things in place and why we need other things in place, okay? Right, so the agenda today, we're going to talk general principles of estate planning, what it is, understanding the differences of terminology and things like that, what it is when we're talking about the types of planning that we have, and then the available resources that we are going to have available to individuals. Okay. Oh, when it comes to the questions, for those of you who are in the Zoom today, feel free to put your questions into the chat as we go. I do keep the chat box up. I do try to answer people as I go in the chat. While I'm speaking, if, however, if you prefer to ask your question verbally, I ask that you hold that until the end of the presentation, and I'll answer those at the end of the presentation. For those of you who are watching this via a live stream, go ahead and put those into the comments, and someone does monitor those, and then they will get asked at the end, or they will get typed into the chat into the Zoom, or they'll get asked at the very end. Okay, so just for those of you who have the questions, but otherwise, if you want to ask the question verbally in the Zoom, please hold them into the end, but put them into the chat. All right. Okay, so advanced planning versus probate. What are the two here? So as Ms. Nia says, this is kind of the beginning. We kind of have multiple parts to our sessions that we kind of talk about. So today, part one is going to kind of be talking about the general, like the principles. What is advanced planning? What, the different types of things. Advanced planning today, we're going to talk about is what it is. Like advanced planning is the before, two sides, right? Part one, the before part. We are preparing, we are anticipating the possibility of incapacity and the eventual death, right? We are planning for death. And so we are preparing and planning for death. It happens to us all at some point in time. Hopefully after a long and happy, prosperous life for us all, but we are planning for death. Incapacity, what is incapacity? That is when we are still living, but we are no longer able to make decisions for ourselves. It is a mental incapacity. It is also possibly a physical incapacity, right? So, but it's typically a mental incapacity. We are no longer able to make decisions for ourselves. So only what people think about when we're thinking about a mental incapacity is that we are living with some form of a dementia. That can be like an Alzheimer's, but it could also be a physical incapacity, which is that we're living in a coma, right? So that is some type of an incapacity where we're not able to care for ourselves. But we also could be but planning is also for people who are in our care. when we are no longer able to care for them. So these are minors, so our children that we care for, or anybody that are in our care, right? So our children who are in our care when we are no longer able to care for them because we have passed or we are incapacitated and are not able to care for them. But it also includes those who are adults in our care. So adults that are our children or our wards that are incapacitated, that are under our guardianship, then we also have to plan for their care when we pass or when we are also incapacitated, no longer able to care for them. And part of advanced planning is also our own long-term care. We are an aging society. We are living longer as a general rule as a society. And as a result of that, we also need to be thinking about how to prepare for our own long-term care. And that typically is a financial planning to some degree, but it's planning for medical care. So that is thinking in terms of living longer, in terms of like preparing for access to Medicare, Medicaid, living in long-term facilities, and things along that lines. We will not be talking very much about long-term care. That has its own complexities in terms of planning for that, but that is part of long-term care planning. And so in terms of advanced planning. So that is kind of the scope of everything that is advanced planning. And then kind of putting it into, not kind of, it's putting all of that planning and thought process and what we want to happen in terms of what we want to do with our property and our children and all of our thoughts put it into writing in a legally binding document. That is what advanced planning is. And so that is, I'm sorry, I was reading a question. So that is what advanced planning is. So that's the before. That's what advanced planning is. So then there's the after. That is probate. So that is typically what we call probate. Now, probate is a specific term. Probate is a court process. It's the court process of handling the estate after a person passes away. That is the definition of probate. That is what probate means. And that is, generally the process is filing an application in court that does require an attorney in the state of Texas. It does require filing with an attorney. It is the general process is paying off the debts, it's conveying property ownerships, managing any of the estate matters, which includes issues involving individuals under legal care of the person who has passed. What happens in that court process depends on the advanced planning documents that were executed prior to death. Was there a will? Was there a trust potentially? Or if there is no will, that what happens in that probate process depends on those documents that may or may not have existed. And that is basically what the probate process is. The complexities of that probate process, again, one, whether or not those documents existed, and what does those documents say? That's essentially what's going to happen in the probate process. That's what it is. Some people will kind of refer to probate as anything that happens after, like what happens after a person passes away, and kind of like, any transferring of the probate like any of the transferring of the probate of the property after a person's passed away. That's not accurate. That's not an accurate description of the term, right? It referring to any process after a person passes away, what happens to property after a person passes away, has probate is not accurate, because probate is referring to the court process. So sometimes people might be like, oh, probate is clearing title. That's not quite accurate, right? It's not quite, it isn't accurate. Probate is the court process, but things that happen after a person passes away is going to be things like clearing title. You can do that in other ways other than a probate process. Like you could also do things, including like an affidavit of heirship. That might be a process that might be available for an estate. So there might be some other things that might be available. So when we're talking about probate, we're talking about a court process, but there might be some other options that are available. We today will not be talking about the after process. Today we are talking strictly about the before, the planning process. So again, as Ms. Nia says, this is kind of a part one of multiple parts. If you are here today because someone has passed and you are wondering what to do because you have property and you're trying to decide what you need to do, you need to clear title and things along that lines. We do have another session, and you can check the calendar, but that is on another Thursday. Next week, I believe it's next week, maybe 2 weeks, but that is what my colleague, my friend, Lisa Nielsen, who will be talking about that. You need to go to that session and you're going to listen to that session and then talk more about what the options are that are available in terms of talking about clearing title, because what you're going to learn, and I am going to talk a little bit about the probate process today as it relates to planning, right? You have to understand a little bit about the probate process in order to understand how to deal with planning. Because if you don't understand that, then you don't understand why we're doing all of this document planning, right? Because as I mentioned, what happens during that probate process very much depends on what documents exist and what those documents say. And that complexity is what makes that process go smoothly and easily, and how expensive that process can be depends on the documents that exist. And so I'm going to talk a little bit about it, but I'm not going to explain the whole process and what you need to be doing and things along that lines. But it's, so just know I'm not going to be answering probate questions today. But but we want to ease that probate process for your family and your loved ones, because again, that can get unwieldy and complicated and difficult. And so when we're trying to ease that process, you want to have good documents in place. And that is what we're going to be talking about today. The majority of the time that we will be spending today, we'll be talking about documents preparing for death. One of the key takeaways today is the most important one, not the most important one of the key takeaways is that someone must do something after a person passes away. When a person passes away, the heirs, the executor must go speak to an attorney to understand what the next step will be. You do not want to wait. You don't want to, the delays can make the process after a person passes away much more complicated, much more expensive, and can be very difficult to solve a title problem the longer families wait to deal with it. Individual plan, I've already talked about this quite a bit already, but a lot of it just kind of depends on what's going on. Family members, dynamics, type of property that's owned, who's inheriting, do they have special needs we need to be taking into account? Are they children? Are they disabled adults? Do they have government benefits that they're receiving? Are they receiving those benefits due to a disability because they cannot work because of that disability? Those are things we have to take into consideration. Current health condition, long-term health conditions, the family history, those are things we have to take into consideration. And the reason why those are important is because you can't just borrow somebody else's will. Your neighbor may look exactly like yours. You're married, you both have two children, same age. It looks very similar. Your neighbor's like, hey, I just hired an attorney. We drafted a will. Our families look alike. You can just copy my will, right? We know we're similar. You don't know that. There's lots of things. That lawyer probably spent a lot of time doing questionnaires, interviewing their client, getting a sense of what's going on, have asked some questions, and has looked around corners about that individual family's needs and understanding about their property and their family dynamics, that they might not even realize that attorney has looked around those corners, has asked those types of questions. And then, so the document may look pretty boilerplate, right? Standard language, but they may not have realized that attorney may have actually seen some nuance and has written language into that will and taking things into consideration that may not apply to your individual family and your individual needs. And so you have to kind of be taking into account that every family is unique, and there may be something different going on in your family that you need to make some kind of individual distinction in your own advanced planning. When should you be updating your documents? I am a firm believer that things can happen at any given time, at any given place. And so you should always be updating your documents. So when do you need your will? As soon as you realize that one day we're going to pass away, right? As soon as we realize we're going to pass, that's when you need a will. So as soon as you turn 18 is when I think people should have wills and other estate planning documents in place. That's because I'm bad news Jessie is kind of how I always kind of joke about who I am. But other than that, it should be at your major life events is when you should be updating your documents or at least reviewing them to make sure that they still reflect what you want. And major life updates are going to be changes in marital status, marriages, divorces, separations. People don't tend to remember to think about updating their documents when they get separated. Some people can't get divorced when they separate. That's expensive to get divorced sometimes. So they separate, right? People, they're like, well, we separated. We're not going to be able to get divorced because we can't afford a lawyer right now, or we can't do it on our own for various reasons. And so once you separate, you should update your documents to make sure that your estranged spouse is not going to be inheriting or making medical decisions on your behalf, right? People don't think about that often. Children, when children are born, unfortunately, when children pass, but also when they age up, when they turn 18, is also, or whatever, usually when they turn 18, but also at other age points, right? Sometimes when they turn 18, you want 18 is for when you're thinking about care, because when they're 18, they can take they're no longer minors, so they can care for themselves. But there's also a distinction of like when they inherit property as well. So some people, yes, the children, they don't need a conservator, like they don't need someone to take care of them, like physically, but they may not want their children to inherit if they're people of assets. They may not want their children to inherit lots of money when they turn 18. And so like, yeah, we don't need someone to take care of them, make sure they're fed and housed and things like that when they turn 18 years age, because they don't need it, but they may not necessarily want them inheriting a lot of money. And so maybe, yes, 18, they can take care of themselves, but if they're going to inherit a lot of money, they still want their children to have that money in trust that they should inherit. And so they'd be in trust until they turn like 25 or something like that. So things like that, right? Those are factors to consider if you're a person of assets. Health changes. When you have your health changes, you're going to want to take a look at your documents. And then, of course, major property changes. And I mean major property changes. When I talk about what's a major property, inheritances, property where there's title to it, like if you buy a house or you inherit a car, you're going to want to take a look to make sure that do you need to change anything? You want to do your, is there something you need to consider? In heirloom property, those are the types of things we're talking about. We're not talking about like, um, you know, I don't know what people would consider a major property otherwise, but that would be the kind of stuff that we're thinking about, like high value property that could potentially cause fights, that type of stuff. Choosing your representative. All of these documents are going to have some type of representative. Like they're going to be called different things, agent, executor, things along that lines, right? They're all going to have kind of a different name associated with, but they all serve in a similar type of role, which is that this is a person that you are selecting to step into your shoes. This is a person who is going to be making decisions, acting on your behalf when you are unable to do so because you are unavailable for whatever reason. An executor is stepping into your role because you have passed. They are now stepping into your role to serve as the executor of the estate, handling the affairs of the estate. And then the agents for the other has the guardian serving as your caretaker. For power of attorneys, they're serving as, again, kind of your caretaker, is your agent, making decisions on your behalf when you are unable to do so. And so when you're picking these persons, you're choosing someone that you know and trust who will do what's in your best interest or will make decisions as you would do so. The thing about choosing these individuals is that believe it or not, like this can be actually the sticking point. I've had clients where this is it. This is the part that can be the stopping point where clients can't get past it, and we can sit for months sometimes where we don't, everything else is drafted, we're ready to go, but we can't pick the person and we can't move forward. Because it's not always who you think it's going to be. This can be a very, very difficult decision. It's an emotional decision. And you're wondering, like, why is this such an emotional decision? Because it may not necessarily be the natural choice, right? Because you want it to be the person who you trust and you can make this kind of decision for it. It may not be your spouse, believe it or not, right? Sometimes when people are married for a lengthy period of time, right? They've been married for 45, 50 years. do you necessarily want your spouse who you've been married to for 50 years to be serving as the executor at the time of your passing? They've just lost a person that has been their life companion for 50 years. They're going to be grieving them, and they may not necessarily be in the right emotional state to be taking on the role of someone doing paperwork. This is a job. And I don't mean to make it callous or anything like that. The role of an executor is basically administrative. It is an administrative job. They are working with the attorney to file documents with the court. And then what does the executor do? The executor works with the attorney. They are collecting paperwork. They are doing accounting. They're filing taxes. They're working with the attorney to draft deeds. They may be working on selling the home. They may have to do repairs on the property before they sell it. They're working with a realtor. They may be conducting a garage sale. They may be right,
tax ID, opening
tax
separate bank
IDs,
accounts.
right. This is an administrative role. And so like, and I think that when people are like, oh, I'm just picking a person to do something, right? Understand what the role actually is that you're asking them to do. Similarly, when you're asking a person to serve in the medical power of attorney role or a guardian of the person role, like you're asking a person to make medical decisions. So a person, so your medical power of attorney, you've been in a car accident, and now the doctor's like, what would you like us to do? We got to make a decision on the, what's the step you like to, there are two options in surgery. What would you like us to do? And so when you're thinking about what you're asking somebody to do, that can change who you choose, right? And it may not be the person that thinks it should be them, right? Well, I'm the oldest child, right? Some of it's obviously you're gonna be your spouse, right? Like it's like well, medical power of attorney. Well, it's my spouse, right? Like obviously it's gonna be my spouse. But maybe you're not married and it's your children. That would be your children. That well, it's my oldest child. Well, maybe it wouldn't be your oldest child, right? Like it's like well, it might be someone else, right? Or it's like well, I don't want any of my children to think I don't trust them. I don't want one child to think that it should, like, I want all my children to think I trust them with my life. And so you get kind of like this stagnation and this kind of like thing. But really, push comes to shove, you probably would pick one, right? Or maybe you won't. It's a very, very difficult kind of conversation to have and kind of difficult thing to think. So I'm not here to tell you how to pick a person and things along that lines. Only you know who you need to pick, right? Who you should be selecting and things along that lines. The hard part is that one of the reasons why you do the advanced planning is to avoid family conflict, is to avoid conflict and to make sure that as these decisions are kind of moving forward, that you are able to have the ability to move forward and make these decisions. If you need to seek counseling to do so, do so. There are services available if you're a person of faith, and you have a faith institution, seek that assistance there. You can seek out counselors, therapy session that they can assist with kind of helping those work with the attorney. I have definitely worked with clients to have these conversations on who can help with the conversations to discuss on like what would make the right choices and that work best for that individual plan, this individual plan with the client and works with the family, things like that, on like who would kind of be the kind of conversations that would be had on who would be the right choice to kind of move forward on that. But ultimately, what you're trying to do is to select the person that's going to be making the decisions as you would be making in those situations. Things to consider, you want to select one person. You don't want to have shared authority. Think of it this way. They're driving a car. Do you really want two people behind the wheel when you're driving a car? And that's really kind of what discuss this with the person that you've selected, give them as much information as they need, so that way when you're not available to give them insight into how to make a decision, they are able to make those decisions without you being available. And then just as important, have these conversations with the people who are not selected. When people think they're going to be the ones that are going to be chosen to make these important decisions in your life, and you're not there to explain why they weren't selected, people create stories in their minds. Did mom not trust me? Did she not love me enough? Did she not believe I could handle it? And you're not there to explain why the answer was no. They're going to carry that. And so give them that gift of also explaining the no as well. And then, of course, you're going to want to have alternates. Sometimes that's also the other way to kind of handle I can't choose. Maybe having one for one, having another person for another role. The most important part, if you're going to have kind of one for one role and one for another role, be sure that they actually cancel, that there's not going to be conflict between them, because sometimes even though they may seem like they're distinctive roles, they still have to be able to collaborate and work together, because sometimes conflicts can still come up between the two different roles. All right, now we're going to get into the will. So the second key takeaway, despite anything else you may hear after this slide, everyone needs a will. No matter what, everyone needs a will. It's better to have a will and not need it than to need a will and not have it. So everyone needs a will. Understanding property and transfer on death. There's a lot of misconceptions about property. Ms. Nia already mentioned this at the very beginning. We are talking about Texas law today. Texas actually has some pretty good law as it comes to property and passing in Texas. But it still doesn't lead, but there's still a lot of misconceptions about how property kind of what kind of happens. But let's make sure that people understand what actually happens. So, because I think that people think because of some of our good laws, they were like, oh, it's easy peasy. It's not. It's not just because we got some good laws doesn't mean it's easy peasy. So first one I get is, I don't own anything. I get a lot of I don't know anything. And so I don't need to have a will or something like that. Everyone owns something. Everyone owns personal property at the minimum. You have your clothing, you have your jewelry, you own something. Everyone's got something. And so what happens to your things, right? And so and that's the thing, right? It's like, well, I don't own a house, I don't own a car. So when I hear I don't own anything, they're thinking I don't own anything of value. I don't own anything substantial. I don't own a car and I don't own a house. But you do own your things. You own your furnishing, you own your car, you own your jewelry, you own your things. So if you're renting or you're living in you're a roommate, you live with somebody, you live in your kids' homes, whatever, right? You still have your stuff. Like, you still have your stuff. And someone still has to do something with your things, right? You may have a bank account, right? A lot of people still actually have bank accounts, right? You may have a bank account, you may have your personal property, like that. Someone still has to be able to do something with that, like, right? Now, it doesn't mean that you need a quarter, like you may or may not need a court account. Someone just was yelling outside my window here. So depending on what's going on with that, there may or may not be anything complex happening with that, but someone still has to be able to do something. If you do have an apartment and you have someone has to be able to go into that. Landlords can't just let anybody willy-nilly into your apartment, and they can't just let anybody take stuff out of it, right? After a person passes. So someone still has to be able to go in and who's going to do something with that, right? Like, who's going to, like, are we going to just are we donating it? Are we selling it? Things like that. The more complicated personal property that exists, though, is the bank account, checking account. People can't just take bank account. Banks don't just give money to people, right? So people still have things, and we still have to figure out who's allowed to get that personal property and what's going to happen to it. So, but even if we assume just furnishing, things like that, what's going to happen to it? If we're going to have, are we donating it? Are we having a garage sale? And then who's going to organize the garage sale? Who's going to get the money from the garage sale? What's happening? What's happening with the stuff, right? So that kind of brings into the next one. Someone must have the authority to do something with that property, and who's going to have the instructions, and who's going to go with that. Title property must go through a legal process, right? So I get things like, oh, the kids are going to get the property, right? Well, okay, right? Like, but they still have to do something with that, right? Like, but what if they just like, okay, but are they going to sell? So, but who's going to sell it? Who's going to decide? Are you going to fix the house first? Or are you not going to fix the house first? Who's going to agree to how much the house gets sold for? Right? So right, think about like all these kinds of questions. Someone's going to have kind of like this responsibility and this kind of questioning of like the ultimately who's going to be able to make those final decisions. What happens if someone had assisted with the caring of the home? What happens if like someone came in and like, someone had to help like repair the roof like 20 years ago? Like, right. It's like, oh, remember when mom had to have the roof repaired and like Susie came over and like gave $10,000 for that? Does Susie get that $10,000 back? Or is it like, was that a gift? What if Susie doesn't think it was a gift? What if Susie thought it was a loan? Right. So so there's kind of like these questions that kind of come into play when we're talking about what happens when you don't have these things kind of in place. The other one that I kind of get is we have an agreement. Fantastic. Put that in the writing. When it comes to land in the state of Texas, verbal agreements, verbal contracts have no legal standing. There's no such thing as an enforceable verbal agreement. So, and also, what if you don't actually agree, right? Like I always like this, like when they're like, oh, we have this understanding between, what if you actually don't? Like, it's like when you like, well, we understand each other. Well, then you got to put it in writing because two people can actually say the same thing and they walk away and they actually don't actually agree to the same thing because people think words mean different things like all the time, right? Like people will, I mean, I'm sure that has happened to me before. I'm sure it's happened to y'all before. And so it's like, great, fantastic. Write it down so that way everyone actually has something in writing. But in general, the law doesn't support that. So if you agree to something, put it in writing so that way it's enforceable. Because honestly, just because you agree to something, when one person passes away doesn't mean the other person is going to do what they said they're going to do, because promises get broken all the time. And the other one that's a misconception is that a co-owner of a property doesn't automatically get the property when someone passes away. This is a misconception about community property in the state of Texas. So the misconception is based on how community property works, right? So the misconception is born out of a true thing that happens with community property. So in Texas and community property, spouses buy property, and so the true thing in the state of Texas is that when spouses buy property and all of their children are the children of the couple, and there's no other children from previous relationships, when one spouse passes away, the property is automatically inherited by the spouse of the surviving spouse. They still have to go through a process. It doesn't mean that there isn't no there's still not a, doesn't mean they don't go through a process. They still have to go through that title property still has to go through a process. But they do own the property. So this is the misconception, right? There's two misconceptions happening, right? So they still own the property, but they still have to go through a process, but they do own the property. So that is a true statement. However, even in community property, if there is children from a previous relationship, so community property, there's a child from a previous relationship. Well, the property is now not inherited by the surviving spouse. So the person who's passed has a child from a previous relationship. Well, now the surviving spouse doesn't inherit the property. The surviving spouse keeps their 50% of the property, but that 50% of the property of the spouse who's passed is now inherited by all of the surviving children, all of the children. So the two children of the couple plus the third child from the previous relationship. So so the community property is not inherited by the surviving spouse. So it's true in one situation, but it's not true in another situation. So this idea that a surviving spouse inherits everything is just untrue, right? So depending on your circumstance, it may or may not be true. So you kind of have to understand like what's going on in your individual situation for you to understand that. So this is the reason why it's kind of like, don't assume just because something is true in one circumstance, it's always true in the other. So I spend some time kind of breaking down these things instead of going deeply into documents, because people come and are like, just talk about the documents, Jesse. The documents don't mean anything if you don't understand what you're writing, right? And so if you don't understand what you're trying to write, you're going to write a document that doesn't accomplish what you're trying to accomplish. And then you're going to create more problems for your heirs than what you're trying to solve, right? So you have, and these are just some of the common misconceptions that people have. So when you're going into writing a document and you're going in to try to figure out what you're going to do, you have to kind of be thinking about what it is that you're trying to accomplish. Ultimately, at the end of the day, that's what the goal is. Everyone's still going to need a will, no matter what, because we need to be sure that we have a stop measure that protects everything. But when we're going in and writing our will, thinking about whether or not we need a trust, whether or not we're going to need a transfer on death document, all of these, and we're about to talk about all these documents. The goal is, what are we trying to accomplish with our advanced planning? What is the goal of our property that we're trying to achieve with our property at the end? After we pass away, what are we trying to accomplish with our property at the end? And what do we want to, who do we want to make sure it gets done? And how do we want it to be, what do we want to happen at the end of it? So last will and testament. A will is a legal document in which a person called the testator writes down what they want to happen to their property and debt, collectively called the estate, after their death, and what they want to, and who they want to manage the estate. That's known as the executor. It covers probate assets only. So what are probate assets? The best way to just talk about what a probate asset is to discuss what is not a probate asset, which is non-probate assets. Non-probate assets are property that are owned in such a way, it's kind of defined by our folks in Austin, that ownership transfers to a specific person without going through the probate process. Probate process, remember, is that court process. I discussed what probate process was at the beginning. So non-probate assets are retirement accounts, IRAs, 401ks. You're going to name a beneficiary. You're going to go to the financial institution where you have your IRA, 401k, etc., and you're going to name the beneficiary. Life insurance proceeds, you're going to go to the financial institution, name your beneficiary. Payable on death accounts, those are going to be on checking accounts, saving accounts. You're going to go to your bank or credit union, name your beneficiary. So those are your three major financial accounts. So those, I'm going to talk about those three first. You're just going to name your beneficiary. So how do those work? You're going to name your beneficiary. When a person passes away, the beneficiary is going to go to that financial institution. You're going to say, hey, the account holder has passed away. They're going to say, so sorry for your loss. This is what you're going to do. You're going to give us a copy of the certified death certificate. You're going to complete some paperwork for us, and then they are going to distribute the funds according to the beneficiaries, the allocations for the beneficiaries, and then they're going to distribute that. And that is it. That is the process. And so when you are updating your documents with those major life changes, you're going to update and double check that your beneficiaries are up to date. They do not go through the probate process at all. And so we're going to use a life insurance policy as kind of a example of how things kind of work. And I'm going to use as an example on why it's important to have a will as well, right? So say there's a $10,000 life insurance policy. So what's going to happen is that a person passes away. You've named Bob and Susie as your beneficiary. After you pass away, Bob and Susie are going to contact the life insurance company. I'm just going to illustrate this, right? Bob and Susie are going to contact the life insurance company. They're going to be like, okay, but that certificate, they each get 50%. They're going to contact them. They're each going to get a check for $5,000 because they're 50% beneficiaries of that life insurance policy, right? So just keep that in mind. So that's how it works. So when you are So that's how this works. Now, joint tenancy with the right of survivorship is the fourth type of non-probate asset. Now, this is the exception. So when we go back up to the co-owner doesn't automatically get it. We have a joint tenancy with a right of survivorship. This is a way to create it where the survivor does get the property. Okay. So this is an agreement where the two individuals, upon the death of one, the property does go to the survivor. Now you can create this. Now, this is not the standard. This is not what happens in the state of Texas automatically. You can create this where you set this up where the property automatically does go that. Once you do set this up, I do always say, be prepared. This is a buyer beware. Be sure that before you do this, that you really think your way through this, because once you create this, it's hard to undo this. There are other ways to make this happen, through a will, through other documents to make this kind of happen with the right, so I kind of say always talk to an attorney before you actually do this. But you can actually create a joint tenancy with a right of survivorship if you wish to do so. Okay. All right. I'm kind of flopping around. I'm kind of bouncing around a little bit. So sorry, just kind of stay with me. I promise it's all going to connect. All right. The thing that I want to take has kind of the takeaway from this slide is that you want to be sure you have access to the bank account and the beneficiaries that are named. And so the way that you do that is going to be the payable on death account or a joint tenancy with a right of survivorship. Those are your two options on that. So access to the bank account is the key takeaway on this slide. Most people have 4 kind of major assets that they have to worry about. Your personal property. Most of that is not really kind of a big issue. You can do that in a will, kind of saying how you want your personal property kind of be taken care of. But otherwise, what we have is our bank account. Our second one is our bank accounts and our cash accounts. That is our biggest thing that becomes a big issue when we pass away. Banks don't just give our money to people. And so you typically have to worry about how are people going to get access to our bank accounts. There's 2 ways that you can do that. You can do that with a payable on death account. You're going to go to your bank and you're going to make your bank account into a payable on death account. They do not own the account. They don't have access to your money in any form, shape, or fashion. So what will happen is that you will go to your bank. You're going to name the person as a beneficiary. Upon passing, they will go into the bank with death certificate, and then the money will get distributed to the person has a beneficiary. That is one way to get access to the bank account. And then they do not have to go through a probate process. I've had clients who come in needing a probate process simply for the sole purpose of having to get access to a bank account. Sometimes they don't even know how much money is in the bank because the bank won't tell them how much is in the bank account because they're not an owner. They have no idea. And sometimes we'll go through a whole process and it will be a very small amount of money in the bank account that wasn't even worth the process of going through it, but they have no idea because the bank won't tell them, right? And so, this is a way to give your heirs access to the funds without having to go through a probate process. So this is a way to think about how to avoid the probate process. If you're talking about what do I own? What do I own? I own my personal property. I have a bank account, car, and a mortgage. We're going to talk about each of those things. We're talking about bank accounts right now, right? You can do a payable on bank account. So that's one option. The other option is to make them a co-owner on the account, right? To actually make them a co-owner on the account. Now, a co-owner on the account doesn't mean that they automatically are the joint tenant, that they automatically get the money, right? They technically don't. Technically, the account owner, the heir to the property is according to the will, right? Technically, that's because just because you co-own an account doesn't mean that they're the owner of the money, right? Because the way that we own property is that just because you co-own something, remember what I said, co-owners of property does not automatically get the rest of the property when a person passes away. That is not the standard in the state of Texas. you can make a property joint tenants with a right of survivorship, right? So you can make your bank account a co-tenancy with a right of survivorship. So that way a co-owner on the property automatically owns the bank account, like your co-tenants. And so that's another way that you can make it so that way a co-owner of the account automatically do that. Now, there's things to think about when you're adding somebody to your bank account. They're a co-owner, right? That means if you add somebody to your bank account has a co-owner to the account while you are still alive and they're now co-owner, they can come in and take that money, right? They can steal your money, again, bad news, Jesse. We gotta be careful about who we have access to our property and our things, right? You gotta be sure these are people that you trust are not going to steal your money and and do things bad to you, right? And so just kind of be aware of that, right? It's very hard to undo things once that kind of stuff happens, right? But you can always talk to a bunch of lawyers, and lawyers will always be like, be careful of the bad things. But that's another thing. That's another way that you can also give access to your heirs and beneficiaries by making them a co-owner on the account. And then by making them a joint tenant with a right of survivorship on your bank account, they now, upon your passing, will become the co-owners of the property. So those are two ways to give people access to your bank accounts, where upon passing, where you don't have to go through the probate process, payable on death accounts, and then joint tenancy with a right of survivorship. Okay. And so, but those are things that obviously you would talk to your financial institution to be sure that you talk about. And so, right. You see, there's some notes in there. I see some lawyering happening in the comments. But so these are just things to kind of keep in mind. And I realized I did not quite finish my whole thought process on the life insurance policy when it comes to needing a will. Now, I'm going to do that right now. So now we're talking about the types of wills. There's two types of wills that we have. I'm sorry. It's been a long day. So now we're going to talk about the types of wills. In Texas, there are two types of wills if you're going to be drafting your own wills. Part 2 of my presentation. So in 2 months, in April, I will be doing a presentation on how to draft your own wills. If you are eligible for services and you apply for assistance with either Lone Star or our other partners, Houston Volunteer Lawyers or Carl, we will help you write your wills. We will help write your wills, like we will get attorneys to draft your wills. But if you do decide to write your own will, we do a presentation on how to write your own wills. But in Texas, you can write your own will, and that's a holographic will. And that is 100% in your own handwriting that is signed and dated. So you take out a piece of paper, write it with your own handwriting, and then you sign and dated. When you are doing a handwritten will, when you go to court, when you go to probate court, there is no need for there's no need for a witness, right? So when you're writing your own hand will, it's literally your own your own handwriting. You don't need any witnesses. But when you go to court, you're like, Your Honor, here is a handwritten will by the person who has passed. The court is going to require 2 witnesses to come to court and say, these are 2 witnesses that know the testator's handwriting. That can be pretty darn difficult to find nowadays, and so when you are doing a handwritten will, it is optional to have 2 witnesses over the age of 14 to be witnesses to the will. Okay. And then when you are admitting a holographic will, which is a handwritten will again, what will happen is that when you go to court, it's like, Your Honor, here is a holographic witness will. Then the court will say, okay, I will need you to bring one of those witnesses to court to testify to the validity of the will. So basically it's like, yes, Your Honor, I was a witness. I saw the testator sign and write that will. I'm not testifying to the handwriting. I'm testifying to the will, that he was the person who wrote the will, and I saw him write the will and sign and date it. Okay. And then there is an attested will. An attested will is just a will that is 100% typed. So you can take out your typewriter, for those of you with typewriters, or a computer, you're going to type it up and you're going to print it. And then in Texas, for a typed will, what is required is that is two witnesses over the age of 14. So once it is typed up, that witnesses, now everyone's going to be watching everybody. You're going to sign and date it. The witnesses are going to sign and date it where everyone is watching each other sign and date it. The witnesses are aware that you are that they are watching you sign and date a will. So it cannot be that they're sitting at your desk and you're like, hey, I'm signing them, watch me sign and date this piece of paper, but they don't realize that what they have watched you sign and date is a will. They have to be aware that you have to say, hey, this is my will. I'm asking you to witness me sign and date my will, right? So they have to be aware of that. And then just like the holographic will, when there's witnesses, when you go to court, Your Honor, we are submitting a tested will to the court. The judge is going to say, okay, I need one of these witnesses to come, and the witness is going to come to court and testify to the judge. Yes, Your Honor, I was there. I saw the testator sign that will that day, and he was of sound mind and testified to the validity of the will. Now, it can be difficult to find a witness, right? Witnesses can be difficult to find. We have two because we have one and a spare, right? But witnesses move, they also pass away. Sometimes they just can be difficult to find. And so there is an option, right? So sometimes we talk about the notary. It's like, oh, is a notary required? A notary is not required. It is an option. It is optional to have what is known as a self-proving affidavit. A self-proving affidavit is an affidavit signed by the testator and the witnesses and a notary at the same time. And so when you are doing when you are doing a will, it is highly recommended that if you are able to do it with a notary, because then when it comes to admitting that will to court, then what will happen is that, Your Honor, we are admitting a self-proved will, and then the judge will say, okay, I will admit the self-proved will. No witnesses are required at that point in time, which makes admitting the will significantly easier. If you are drafting your own will, just be aware that not all notaries will sign a will. So don't just assume that you can just go to any old UPS store and ask them to do that. Not all of them. Actually, I'm not sure I've ever heard of a UPS store that will notarize a will. Not all banks will do so with their notaries there. So you do need to call and be sure that if you are doing this on your own, that you call the notary and ask them if they are willing to do that as part of AMOS, just so that you are aware. The NRCDC they do have notaries that will notarize the wills that you are drafting on your own. You would just have to call and schedule the appointment. And I believe that Ms. Nia includes that information in her emails. All right, now what about the fill in the blank wills? This one gets a little bit complicated. Generally, the law has actually not changed in Texas. The statutes are written in such a way that makes it pretty clear that there is no such thing as a fill in the blank in the state of Texas. The statute is still written as it is written, which is that it has to either be 100% written in your own handwriting or 100% typed. That the law still says that. So the law has not changed. However, there is the Texas Supreme Court has done what is a fill in the blank pro se will form. And so that has been promulgated by the Texas Supreme Court. And that form does say at the top that you can use that as a fill in the blank form. I will say this, that form will get shared with you. That is the forms that I talk you through in my presentation in 2 months. I do recommend that you do not do that as a fill in the blank form, because the statutes don't say that the statutes still say it has to be either 100% type or 100% written. So if you have access to the computer, I do recommend that even if you are using the Supreme Court forms, that you do fill in the form with the computer and print that out and do use it as a fill in the blank form in that way and do it that way. But according to the form, you can use it as a fill in the blank form, but I do recommend that you still type it up and print it out and then notarize it and sign in and notarize it has in that way. A will, yes. I'm asking if the will is notarized, it is valid. Yes, the will has to be witnessed. a will that is typed must be witnessed to be a valid will. It cannot just be only notarized. So it must have two witnesses to be a valid will in Texas. So it cannot just be you signing it with a notary. So it must be, if it's a typed will, it must have two witnesses. It can be notarized with the two witnesses. Okay, so just to be clear on that, the only time that a witness is not required is if it's 100% in your own handwriting. But so just to be clear on what is a valid will in Texas. Another option for next option for documents is what are called transfer on death documents. Transfer on death documents are a way to transfer property without going through the probate process. There are two types of documents, which is a transfer on death deed. This is for real property. This is for houses and land. This is a deed, just like a warranty deed, a quitclaim deed. And then there is for your vehicles, which is the beneficiary designation of a motor vehicle. This is your car title. Looks like a car title. For both of these, you still own the property. You can do whatever you want with it, including selling it. Just because you file these documents doesn't mean you still can't do what you would like to do with it. It's really important to know that a transfer on death document takes priority over a will. And so if you file the transfer on death, the deed, if you file the deed, the TOD, and then you do a will, the TOD takes control. So if you do a TOD and you give the house to Sally, but then you do a will and you give the house to Bob, Sally gets the house. If you do a will, give the house to Bob, and then you do a TOD giving the house to Sally, Sally gets the house. It does not matter when or how you do it. Sally gets the house if there's a TOD for Sally. So that's really important to kind of keep that in mind. So just kind of be aware of that, right? So if you change your mind about who gets the house, you need to revoke the transfer on death deed. And you need as well as the beneficiary designation, because once that's on file, that's going to take effect immediately upon death. So unless that's been revoked, because the property is being passed outside of the probate process, the will never have any effect, right? Because it's never going to actually go into the probate court because it's passed outside of the probate process. The court will never have an option to undo what happens with the TOD or the motor vehicle beneficiary designation. So it's always going to have a priority over the over the will. So just kind of be aware of that. And I have not updated the slide, but there is now an option for you to be able to do the same document with a mobile home. There was a little bit there was a little bit of unclear. There was a little bit of a gap as it related to mobile homes and the statement of ownership when the mobile home was declared as personal property as opposed to real property. And now you can make a transfer on death statement on a statement of ownership for a mobile home as well. You were able to do it when it was designated as a real property. Now, if you've designated a mobile home as personal property, you can now do that in the statement of ownership has for a transfer on death as well. So I need to update my slides for that. But you can now also do that with your mobile home as well for those of you who are mobile home owners. So just be aware of that. Now, the thing about the transfer on death documents is that you got to be buyer beware. It's not ideal for all situations. It's a great opportunity and it's something to seriously be considered for a lot of things. So remember I just said for most people, we got 4 major properties. We have our personal property, which can be dealt with in a will. Our personal effects, what's going to happen with that. We may or may not require a probate process to deal with that. A lot of times we don't need it. Sometimes the instructions in the will is all we need. Our bank, our banking things, we're going to deal with that with either a payable on death account or joint ownership in some way. We got that. We're going to deal with our house, right, which we're going to do with our transfer on death deed and our car and our vehicles, right? So, but sometimes we got to be careful, right? Because the transfer on death options are not always the most ideal situation. We can't put instructions in our transfer on death things, right? So what remember earlier when I was like, what happens if like Susie paid for the roof? What if we wanted to do some kind of instruction in there, right? It's like, well, Susie gave me $10,000 to repair my roof, and I think it's really, we really want to be sure that Susie gets that $10,000 back, right? You can't do that in a transfer on death document. You can't say give Susie $10,000 and then sell the house and split the proceeds evenly, right? You can't even put those instructions in the transfer on death. All you can do in a transfer on death document is transfer the property equally to Susie and Bob. That's all you can do. You can tell Susie and Bob, hey, I really want Susie to get the $10,000 first, and then I want you to sell the property. But you can't force that. You can't control that. They have to figure out to do that on the runsies if they want to do that, right? And so if you want to control that, if you want that to happen, that has to go into will, and that has to be controlled by the executor. The executor, that has to be, that you have to vest that power in an individual to do that, if that's what you want to happen. And so if there's going to be instructions, that may or may not be the place to do it, right? Now, maybe the instructions are enough. Maybe the verbal instructions of Bob and Susie are going to be sufficient. And, I don't know. That's not my place to tell you what to do. But that might not be the ideal situation. Life estates. Now, there are ways to protect a life estate, even in a transfer on death deed, which will be through a probate court process, right? But life estates, what a life estate is that a surviving spouse does have, even if they're not an owner of the property, does have a right to stay in property, right? So, but if you're married and you want your spouse to be able to stay in the property, even though your children are inheriting the property, you may want to do those protections in a will, as opposed to doing something in a TOD. You want to ensure that your surviving spouse gets to stay in their property. You may want to do that in a will to ensure that there isn't some fight, where your spouse potentially is getting evicted by your adult children. The thing is that like the counseling part of this work that I do sometimes is that you're not going to be around to ensure that people are going to be nice to each other. And that's a hard thing to say, because you believe that the people that you love are going to stay nice to each other, and they're going to be kind to each other afterwards, because of the shared love that you have for them is going to remain. And that doesn't always happen. And sometimes part of what we have to do, and sometimes part of what we have to think about, is how do we ensure that we protect the people that we love, even from the other people that we love, right? And so sometimes we got to think about, like, we may be trying to do things for financial reasons and trying to ease things, where really the thing that we might be trying to ultimately do may require the more complicated process, because the more complicated, and I put that in air quotes, because our probate process is actually not that hard. Like, as much as I talk about like, oh, we're trying to avoid probate with all of these things, the probate process is actually not that bad. When you have a well-drafted, properly executed will, the probate process is actually not that. It's administrative, yes, like there is paperwork and we have to go through that process, but it's only actually one appearance in court. And with a well-drafted, properly executed will, it's only one appearance in court, and otherwise everything after that is just drafting documents and filing things in court and doing the work that's associated with it. You still have to do all of that work. It's just a question of when you need to do it. But sometimes using the court as the system to be able to do something is going to be better to actually protect the thing that you're trying to do. Remember what I said at the beginning. What is the goal that we're trying to achieve? That should be the driving factor on what we do at the end. When we're thinking about how we draft our documents, what documents that we put into place, the driving goal should be, what are we trying to achieve? It isn't always going to be, I just want to have the cheapest way of avoiding probate. It should not always be avoiding probate, because sometimes avoiding probate might cause family strife and conflict that can destroy a family that can never be recovered. And you won't know that it happened, and you won't be able to solve it. but we may be able to avoid it just by going through a probate process and doing some planning ahead of time, and by going through what can actually be not a complicated probate process because we've done a well-drafted will that avoids the complexities of a probate process, right? So we have to think about like all of that. So, right. So when I say transfer beware, don't do a Todd because it's the easy thing, right? Because we're like, oh, it's easy. We just do that. We don't have to go through probate because now we can avoid this, right? Because a Todd can actually create a more difficult, because it can create a probate contest. It can create a much more expense because we've done something without thinking about a potential contest that might happen afterwards, right? It may not actually be. So when we're thinking about our planning, think about what we're actually trying to accomplish at the end. What is it that we're thinking we want our family to have, what we want our beneficiaries to achieve when we're drafting these documents? Yes, you can actually have more than one person inherit under a transfer or on death deed. There's always kind of whenever more than one person inherits a property, you always have to think about like what are the potential consequences of that. But yes, more than one person can inherit under a Todd. No, a Todd does not need to be drafted by an attorney, and it needs to be filed in the county where the property is located. I am going to talk about do a Todd and a ladybird in a couple of slides. So give me a minute to answer that Todd ladybird question. Okay. Trusts. So I don't go into trust very deeply in this because trust can get complicated. So, but a trust is an arrangement where a person or an entity called a trustee holds legal title to property for another person called the beneficiary. There are lots of different types of trust: living, revocable, irrevocable. Generally, I do recommend that you talk to an attorney about a trust because usually the driving factor is what I just talked about. What is the goal? What is the goal of a trust? I'm not saying trusts aren't important or an option. I always say, what is the goal? What is the goal of the trust? If the only reason is to avoid probate because you heard about it from a street committee or a TikTok, that might not be a good enough reason, but there are reasons to have trust. Sometimes it is about becoming eligible for Medicaid. Sometimes we have early diagnosis for dementia and we really are planning for, we know we're not going to be able to do estate planning down the line. And so we need to go in and start putting things into trust because of those reasons. There could be, there were some financial reasons for trust planning, but if the sole reason is to avoid probate, there's a lot of other things that we can do to avoid probate for when it's simple estate planning as opposed to complex estate planning. So I would recommend that if you do think that you have a need for a trust, I would consult with an attorney, but there are some reasons for it. You're going to hear a little bit of that in a couple of other slides as we get to it down the line. But that is essentially what trust is. For a lot of people, it is tax planning. Sometimes trusts are is trying to minimize the estate tax amount that gets paid in the estate tax, but just kind of keep this in mind. Avoiding probate as it comes to a trust is actually not avoiding the work of probate. You're just moving the work. The work is the same. The work is actually the same. It's just is whether or not you go to court to do it versus doing it now. And the expense actually might be the same or sometimes even more, depending on the attorney that you hire and the complexities of it, right? So I don't know. I work for legal aid, so I don't know how much attorneys for charge for this, but it may or may not actually save money. But it's you're still hiring an attorney to do the work. It's you know, so you might want to be a consumer and compare and shop and comparison shop is what I'm saying. I got some bad news, unfortunately, which is debt survives. There's a misconception around debt when people pass away. Some creditors will discharge the debt. And so I think this is where people get kind of that misconception, which because some people are like, oh yeah, they no one no one made me pay for anything. And it's like, well, that's actually not true. The estate is still responsible for any debt that is remaining after a person passes away, but the estate is responsible, not the heirs. Sometimes it may feel like the heirs are responsible because depending on the debt, the heirs may end up being responsible because of the nature of what is kind of being that has to get kind of paid, right? So the and this is where it comes down to real property as well as any other property that is subject to a secured lien has to still get paid. So mortgages have to get paid. If you don't pay the mortgage, the house is going to get foreclosed, right? And so cars with car loans, the car is going to get repossessed. And so while technically the estate is responsible for paying the debt, if the mortgage doesn't get paid or the car loan doesn't get paid by whoever is inheriting the property, it's right, it's going to get repossessed. It's going to get foreclosed. So we do have to kind of keep in mind. Part of estate planning is thinking about how that's going to get paid. Some folks are able to make sure that those debts get paid, right? Through life insurance, through assets that the estate may own. And it's part of it, and it gets included in the estate planning, right? So or you just let the person know where it's like, hey, you're going to be inheriting the house, but you got to pay the mortgage. And so the person has to kind of figure out financing or they're going to sell the house and just take whatever equities in the house, right? Just be aware, again, I'm not here to tell you what to do and how to handle it or anything on that lines. It's just be aware that if these debts exist, that they are going to be inherited subject to that debt and they have to get paid. But the thing that has to be kept in mind is reverse mortgages. Now, usually for the secured debt, for the mortgages and the liens and things along that lines, if it's a traditional mortgage company, they usually will work with the executor as long as the mortgage and the debt is getting paid. Traditional mortgage companies will kind of work with the estate to allow time for the either the executor to sell the property and pay off the mortgage or for the beneficiary to secure their own financing and things along that lines. But reverse mortgages are different. They are due 6 months after the person passes away. And that is a very short amount of time. 6 months is very fast. And the average amount of time for a probate to get opened in Texas is around 4 months. And so when you think about that, that's again not a very long amount of time for an estate to kind of do the work to sell a property and things like that. So just kind of be aware of that make sure your executor knows that there is a reverse mortgage on the property. So that way they are aware they may need to either move more quickly to start the probate process because if they're going to sell the property, they can do it as quickly as possible. So that way they're not rushing to sell the property. And that, so they can kind of do what they need to do, or if they're going to try to stay in the property to secure financing to be able to pay off the mortgage before the foreclosure happens at the 6 months. Reverse mortgage companies tend to move pretty quickly. They tend to not be as forgiving in working with with that timeline, just based on what it has been the way it seems to work. Disposition of remains is a document that names an agent to make decisions with respect to the disposition of remains, funeral arrangements. Who's going to be making those funeral arrangements? There is a lot of conflict when it comes to making funeral arrangements, so it is just helpful to kind of have this in place. You can name funeral instructions as well as any pre-arrangements or burial plots that might be named in that. All right. Next, we start getting into documents for incapacity planning. These are actually pretty straightforward documents. The rest of the presentation goes pretty quickly at this point in time. Again, I said the majority of this presentation is spent time on talking about planning for death. It is the most complex part. Everything else is pretty standard. Okay. All right. So next up is a supported decision-making agreement. This is an in-between. This is when people are kind of in diminished capacity. We still have some capacity, but we're starting to lose our ability to kind of make some decisions, or we're kind of like not sure what's going. Sometimes there's a little bit of a cognitive decline is kind of more what that's kind of decide is kind of how it's described. It's the document signed by an adult that requests a supporter to help with decision making. The supporter does not make the decision, they help the adult make a decision. The supporter owes a fiduciary duty to the adult. It's less restrictive than a guardian, and it's useful for individuals in diminished capacity. It's really kind of helpful for children who are aging up, as well as adults who are kind of getting older, who are kind of in that in between. So it's kind of like things like someone comes to the bank and it's like, oh, I really want to make this transfer to this person I don't know, and it doesn't make any sense to a person in another country. Then the bank will call the adult and be like, hey, person's here, and can you want to come help do some research and make sure that we're doing the right thing here, right? It's just a protective measure to kind of help. It's not a power of attorney. They can't stop it. They can't make the decision. It's just a little bit of an in-between to help kind of do some protection. A statutory durable power of attorney. The reason why we don't spend a lot of time talking about these is because it's in the name, it's statutory. What makes this pretty easy is that the folks in Austin have already written it for us. It's in the statute. The language has been written for us. It's easy. It's so straightforward. It's a person named to make legal and financial decisions when a person is unable to do so. It's a choice of when it's effective. It's either effective immediately, which is that as soon as a person signs it, they can take a copy of that document, go across the street to the bank and open up a bank account for us if we want to. Or it can be effective springing. That's at the time of incapacity determined by a doctor. That means after a doctor's appointment, a doctor determines that they're no longer able to make a decision, and that is it. There is no right or wrong of when to choose to make it effective. I kind of say it kind of depends on your situation. Like, again, don't substitute my judgment for yours, your individual plan, what works for you and your family. I can let you know in my situation, I have a power of attorney for my mother that's effective immediately for one reason and one reason only. My mom hates talking on the phone with her bank. So everything else she does on her own, if she will go to the bank in person and do everything in bank in person, not a problem for that. But kid you not, during COVID, during lockdown, she refused to call the bank and talk to the bank on the phone. And that's when we executed a power of attorney for me to call the bank and talk to the bank on the phone. And that is the story of how Jessie became her mother. Before that, it was effective phone springing, but that is a true story. And so because she just does not want to talk to the phone on the phone with the bank. But so sometimes right, so that's the true story of my situation. But right, if you already have a person who's already doing things, like already helping and already kind of doing some of the stuff, having it effective immediately because they're already doing stuff, that might be good for your family, right? It takes away the need for a doctor's intervention to be able to do that. That's okay. Or not. You don't have to do it anyway. So, right, for some people, if it's, this might be a way to kind of help. It might not be. So there's no right or wrong here. Usually, but for me, the little yellow flag that I hear is kind of like, well, I don't know that they won't do something without, I don't want them to do anything now because I'm worried that they'll do. That's a yellow flag. If you're concerned that they're going to do something without you knowing, and you don't want them doing something without you knowing, be a little bit more worried about that, right? Because then maybe you might not want that person at all, right? You might want to choose someone different. Like if you're concerned that you're like, hey, I'm going to make this effective immediately so that you don't have to worry about getting a doctor to do an examination just in case you do need, when you do need it, you can do what you need to do. But I don't want you to do anything until you need it. But then, and you're like, ooh, but what if they will? Then you might want to pick a different person, right? Like that's again bad news, Jessie, but you might want to consider that. But there's no right or wrong on whether or not you want to do this. I will say that I've noticed that usually my more elderly clients tend to make it effective immediately because their children or whoever it is that they're going to name, typically it's one of their children, are already kind of doing things for them. And so it just takes a little bit of a barrier away from having to do it, or each individual person that they're like each bank account and stuff like that. So, but that is, it's usually a question I get on which one should they do? So I kind of preemptively answer the question. Next is the medical power of attorney. This is a person to make medical decisions, right, when you are not able to do so. Obviously, it's only effective when you are unable to do so, as determined by a doctor, because as long as you are able to make your own decisions, then you are always going to make your own medical decisions. And so this is obviously when that medical decision is going to be made. Just generally, going forward as it relates to incapacity, there's almost always going to be one document as it relates to medical decisions and one document related to legal and financial decisions. So the last of the key takeaways is that everyone needs a statutory durable power of attorney and a medical power of attorney. That is it. These are the key takeaways for the minimum protections. Everyone needs a will for minimum protections, better need a will and not have it. Access to a bank account. Everyone needs a statutory power of attorney and a medical power of attorney. That's going to be your minimal protections. After this is gravy. I think you should have it. I hope you get it. But if you don't do it, I'm not gonna say it's okay, but hopefully you get it when you have a chance. But these are your minimums. If you're going to be doing this on your own and you're like, okay, Jesse, I've just sat through this 2-hour presentation. I've learned a lot. My brain is overwhelmed. I can only do oh so much. What do I absolutely need to do? You're going to write a will. You're going to do a statutory power of attorney. You're going to do a medical power of attorney. You're going to talk to your bank about doing it as a payable on death account. And then you're going to come back in a month and do the rest of the documents. Okay. All right. Declaration of a guardian in the event of later incapacity. So this is in the event of a permanent incapacity. So the statutory dual power of attorney and the medical power of attorney, those are meant to be temporary in nature. They can become permanent, which is why they're the minimum protections. They can be used as permanent documents, but but ultimately, usually when a person becomes permanently incapacitated, at some point in time, somebody, either a financial institution or a medical professional, will require a permanent, a guardianship will require at some point in time, the power of attorneys will no longer be sufficient and a permanent guardianship will be required. The designation of a guardian in the event of later incapacity is naming that permanent guardian, who you would like to be your permanent guardian. And so it's the preferred person in the event as needed. And so this is when the court process becomes involved. So we're going to go to court. It's a probate court, but it's going to go to court. And then this is going to name who you would prefer to serve as that guardian. You can also name who you would serve to be disqualified. Now, this is because it's a court process, the person has to qualify. So that means the court has to go through a process and they have to qualify this person. And there's different levels of like who can qualify. And then when you're going through this process with an attorney and drafting the documents, you would kind of go through and identify who would become disqualified. And it's usually things like, are they bondable? Are they good character? There's different kind of factors that can kind of come into play. It's hard to get disqualified, but it also can name who is disqualified. So typically the court is not required to name who you name, but they will do their best to name, right? So you name your first person, you name your alternate. If for some reason your named person and your alternate cannot serve, then the court is going to look for someone else to serve. So you've named Bob to serve. Here's your guardian. Bob can't serve. Bob has passed away, right? Then you name Susie, but Susie's in California and Susie is unable to serve because she's in California. She can't move to Texas or whatever, right? There's a reason why Susie can't serve. So now we're going to come and find, Joanna. Joanna is your estranged sister that you haven't seen in 30 years, and you're estranged for really good reasons, right? We don't like Joanna. And, but according to Texas, Joanna is your next of kin, and she's going to serve, as your next of kin, she's the person that should be serving as your guardian. You can name her as someone who can never serve as your guardian. So for some people, that person that's disqualified is just as important as naming who should serve. And so while the court may not name your first and second choice for whatever reasons, like there could be reasons why they can't do it, if you, as soon as you say Joanna can never serve, they will take that 100%, right? They're like, all right, Joanna can't serve. Joanna can't serve. And sometimes that can be just as important for somebody. So you can say Joanna can never serve, and then they'll go look for the next person after that as your next of kin has the potential person to serve as that. So this can be a really important document for people because you can't name a person after that. Two types of guardians: person, this is like your medical power of attorney, making decisions on the care, medical decisions, where you would live, that type of thing. And then the estate, this is property, finances, and legal matters. Just like your statutory, your will power of attorney get two parts. HIPAA release. HIPAA gets a lot of news coverage at different times of the year. HIPAA stands for the Health Insurance Portability and Accountability Act. It protects your private medical information, cannot be shared by certain people without express permission. Certain people is typically medical professionals. It also includes lawyers, lawyers like me, people who obtain medical information in the course of their professional work. We cannot share that information without the express permission by the patient or client. The HIPAA release is a general release that allows us to share that information. So like if you go to your general practitioner and sign a HIPAA release, it's only for that doctor. So like when you sign it for that doctor, that they can't, like a person can't go to your GP and take that HIPAA release and go to your neurologist and be like, okay, neurologist, I need you to give this information, your information, to this person. So this HIPAA release is a general release that allows any medical info to be shared with at least a minimum your medical power of attorney and your designated guardian. An advanced directive is commonly known as a living will. This is into life decision making, and it's a pretty right. It's a heavy document, and it's in two situations for a terminal condition. Those are defined as: a terminal condition is a person's expected to pass or die within 6 months, even with life-sustaining treatment. I am not a medical doctor, so I'm just using just kind of standard language, what will be known as. So a terminal condition, most people would think of as stage 4 pancreatic cancer would be what would be commonly known as a terminal condition. An irreversible condition is a condition that is not terminal, but without life-sustaining treatment can be terminal. So an irreversible condition would be a coma. So a coma in of itself is not terminal. People can live in a coma for many years, but you have to have some intervention. For example, you need nutrition. We need to be fed. And so we would need to intervene with nutrition. So that would be an example of an irreversible condition. For each situation, we are given an option to choose from, which is to stop treatment, keep me comfortable, and allow me to pass peacefully. Use all available life-sustaining treatment. Yes, I would like you to please intervene and use life-sustaining treatment. Within that, you can also make additional instructions, which is you can provide specific instructions such as artificial nutrition. All life-sustaining treatment except for a respirator. I would like to not be placed on a respirator, and in which case I would like to be allowed to pass in that situation. The standard document usually stops at those choices, to leave those two choices at that. And the template that you will receive only stops at that. You do have the option, if you wish, to include a decision by the medical power of attorney. I will say that typically doctors do confer with the medical power of attorney. It's pretty rare for them to just make the decision without conferring with the medical power of attorney, but some people want in the document in and of itself to include the confirmation with the medical power of attorney before decisions are made on this. So I do recommend that you always have these conversations with your medical power of attorney on what your wishes would be in these two situations, but you can include the document to say that the conversation should include the medical power of attorney on what should happen in these situations. Obviously, you should have these conversations with that individual that you have chosen, so that way they know what your wishes are in these circumstances, and what you would like to do in that case. I do encourage that if you are a person of faith, or even if you are not a person of faith, that you do consider having the kinds of conversations with this person beyond just the decision making, that if you do need counseling or anything beyond that, that you have those conversations. These are heavy conversations, and this is likely a person who loves you, and you are asking them to make what is likely a very hard decision. And so I always like to do that counseling part as well. Does this not replace hospice plan? So if you do go into hospice, the hospice plan will govern in this situation. All right. The last document for planning for incapacity is a declaration for mental health treatment. This is also known as a psychiatric advance directive, known as a PAD. This is for individuals who are at risk for a history of psychiatric hospitalization. This is obviously a very individual document, does not apply to individuals who do not need it. It only applies to individuals who do need it. Diagnosis that this may apply for is someone with schizophrenia. So it's a person who's at risk or has a history of psychiatric hospitalizations is what it is. It's for individuals who make decisions in advance of psychiatric medication, convulsive therapy, emergency medical health treatment, such as restraint and seclusion. Obviously, it may not apply to you, but if you know anyone with this type of a history, it is a very useful and important document. Unlike the other advanced planning documents that you would kind of look at in major life changes, this document does expire and does need to be re-executed every 3 years. And so, so just be aware for individuals who do need that document. All right, now for long-term care planning, and getting back to that question about the difference between a Todd and a Lady Bird deed. I did not forget that question. We don't cover this topic very deeply because it is, for AMOS, we are going to have a discussion. We are talking about when to include this as a longer topic. So keep an eye out on the calendar on when we will be having a session on this topic that has its own session to kind of deeply more talk about long-term care planning. So keep an eye out for that. But long-term care planning kind of talks about the eligibility for benefits such as Medicaid and protecting assets from creditors, including the Medicaid Estate Recovery Program known as MERP. For those of you who are not aware of what that is, for those of us who are do go into long-term care, that's nursing home care, and who do use Medicaid benefits for that, the government does have a right to recover some of those costs from our estate after our passing, and that is known as the Medicaid Estate Recovery Program, MERP for short. And so some of what is known as long-term care planning is trying to preserve our estate for our heirs against that recovery plan, right? To try to protect against that. And so there's a couple of things that have historically we have done to preserve that property, which is through what is called an enhanced life estate, which is commonly known as a Lady Bird estate. And so a Lady Bird estate is a life estate. And so what that is that it's a life estate where we have granted the property, we have transferred the property to an individual and retained for ourselves a life estate. But we've retained the right to also live on the property, give it away, sell the property. We've kind of retained it. And that is a way for us to protect, that protects the property against the MERP claim. And so we technically no longer own the property, but we've actually retained some rights to it that is unusual, right? Which also includes like a right to sell it and things like that. It's very, very similar to some degree to the transfer on debt deed, which is that we still own it, but we have given, but the property passes upon our death, as opposed to in reverse. Both the Lady Bird deed and the transfer on death deed has very similar protections from the MERP claim. So there are still reasons to do a Lady Bird deed as opposed to a Todd. But if the sole reason is the MERP claim, without some of the medical reasons to do a Lady Bird deed, then usually the advice has typically been to move towards a Todd. But the thing is that like, as you may have noted the language, there may be medical reasons to move forward with a Lady Bird deed over a Todd. And so generally, this is where that individual plan, and one of the things I said is current health conditions and future health conditions. There are reasons on why we may want to consider doing a Lady Bird deed over a Todd. If the sole reason is to do a MRP protection claim without any other knowledge about a person's health conditions, a lot of the times we're probably looking at a Todd as being a way to just protect against a MRF claim, a possible MRF claim, right? We're looking at a hypothetical MRF claim is kind of what we're thinking about. But if we're looking at a likely MRF claim and we're looking at like a real medical condition, I'm advising to go talk to an attorney. Don't ask this question. Do not ask this question in the chat. I cannot answer this question. So, but we're probably looking at we would need to kind of look at the individual situation on whether or not we're looking at a ladybird versus a Todd. But so there are things to think about in this situation on what, and so that's the difference between a ladybird versus a Todd. A lot of the times a Todd makes more sense. A Todd will do the job. A Todd will do the job. But there are still some reasons why a ladybird will make some sense, even with the existence of a Todd. So that's what it is. We also need to be thinking about like getting people eligible for Medicaid. And so when spouses in the situation, one spouse needs to qualify for Medicaid so that they can get access to the benefits, but the other spouse is still working because we still need income to come into the household. Then we have what is called the qualified income trust, that's commonly known as a Miller trust. This is an irrevocable trust. Once this is created, we cannot undo it. But the sole purpose of this trust is to make sure that the spouse gets access to Medicaid benefits. And so we create a Miller trust so that way the one spouse can continue to work, so that way income can still come into the household, and then the spouse can get benefits, Medicaid benefits. But long-term care planning, again, keep an eye out for that session. It'll probably be in the summer or early fall, just kind of late summer, early fall, as we kind of get that scheduled. But keep an eye out on the schedule for us to talk about this, because we know this is something that is of interest, because again, we're living longer, yay, but we do now have to think more about long-term care planning. All right. So what's next? Some of this is just like practical stuff. This is not lawyering. Some of this is like just gotta do some work on our part. There's so many tools now available out there. Don't go spend lots of money. Some of this is like pretty basic. Like sometimes you just gotta go to Office Depot or your HEB, buy a notebook and some folders, right? Like I always see some of this stuff. I'm like, oh my goodness, who's spending that kind of money? I just have a notebook and some folders in my house. So create a list of accounts, right? Your bank accounts, your credit cards, your mortgage company, write that stuff down, right? If you work with an attorney, they'll give you a questionnaire that you can create all this kind of stuff, but you're going to write that stuff out so that way your executor knows what you got. Make sure that you know what you have. Be sure that your executor can access your digital accounts. There are some useful stuff out there. There's like, password managers and things, so that way, someone knows how to get access to that information. There's always like the jokes like, be sure you wipe out my browser history is like a joke that kind of happens on that. But you want to be sure that people know what you have and how they can find it and where they can get access to all that information that exists out there. Where do you keep your documents? Safety deposit box. I get asked about that a lot. I have no problems with you putting things in your safety deposit box. Just be aware that someone's got to be able to get to your safety deposit box, though. The person who has access to your safety deposit box must be an account holder, and they must have a key. Otherwise, you have to have a court order to get access to your safety deposit box. And so just be aware of that. Nothing wrong with that, but just be sure that it's the person has, again, is an account holder and has a key. Otherwise, it will be a court order is required, and only the executor can get access to the account. But otherwise, the other one I get asked is about the county clerk. You are not required to file your will with the county clerk. That's not a requirement at all, but you can record it with the county clerk if you wish. It is protected. It's not public record. As long it does become public record once you file it after a person passes away, it becomes part of the court records. But before a person passes, it's not. And so you can, it is considered, right, it's a safe location, so that way we could get a record of it, but it's not required. But you don't have to mail it to yourself. That's another one I get. It's like, oh, like do you have to stick it in an envelope, mail it to yourself? It's nope, you don't have to do any of that. Where are your important papers, right? Where's your passport? Where are your social security cards, birth certificates? Put it with your important papers, someplace safe and secure where random people can't find it. And that's where I would put it, and be sure your executor knows where they are. So that way, when it comes time, they know how to find it. And then remember the first key takeaway, that they can take it to an attorney when the time comes. Discuss all of this with your family and friends, not friends, your representative and your family. So that way, when the time comes, they know what to do. And that is, again, go talk to somebody. Remember, everyone needs a will. Be sure there's access to a bank account. Everyone needs a statutory dual power attorney, power attorney. Get everything else when you have a chance, but this is the minimum protections. This was a lot of stuff. I know it was a lot. There is help that's available. Lone Star Legal Aid is me. I know that for those of you who ever watched me do this before, I was a little bit off kilter today. I've had a really busy month. I'm really tired. I'm about to go take a week off of work to kind of rest up, but I am available. Come back in April, I'll be more energetic. But our other partners are Houston Volunteer Lawyers and Earl Carl Institute. We are available to help you. For those of you who may not qualify for services or who want to hire an attorney, Houston Lawyer Referral Service is a service of the Houston Bar Association. And they have attorneys in the private bar that you can hire, and they can give you referrals. Texas Law Help is a great website that's from our partner, which is Texas. I can't remember who they are, but they are self-help, and they have more information not only on estate planning, but everything else as well. And that's texaslawhelp.org. So feel free to go and do that. I know we're right at 3:00, but I'm happy to stay on and answer some questions for anyone who has some. And I do know that there's some in the thing that I might have missed. I do end on a comic, so I'm going to end on my comic, which is Miss Hen is with her attorneys, and she says, I want to leave all of my estate to my sisters, but if she's not living, then in trust for her eggs. A good use for a trust, because minors cannot inherit. So you have to leave it in trust. All right. What questions did I miss, Nia?
I think you went over all of them. You got the one about the beneficiary, the process for beneficiary motor vehicle.
Oh, the process.
Okay.
I did not go over the process. It is once it's you file it with the tax assessor collectors, which I always think I think it's the weird office, but no, it's the same place where you file your your car title. But yeah, you file it and then they send it back to you. And it says motor vehicle designation, and you stick it with your will and everything. Yeah. It's just like
Yeah.
filing for a car title.
Yeah, and it's notated on the bottom of the title when there's one that's already designated, and then that person's name is there.
Yeah.
Okay. Thank you, thank you, thank you. Do you have to tell someone that they are listing you on a tide?
I don't think you have to. I think it's nice. But I think you have to.
Yeah, I guess you probably should, considering if they don't know that they need to go down and submit your affidavit of death after you pass,
Yeah.
then the title will never get transferred. So you probably should tell them.
Yeah, but I mean, like, so same thing when you file. Oh, I didn't tell you must file your TOD when you execute TOD. You must file your TOD in the
That
county where
part.
you where the property is located, and then that record that recorded TOD will be with your documents. And so yeah, so hopefully the executor will see it. But yeah, when a person passes, you do have to file the record of the death, and that, right? But I guess the answer is you don't have to tell somebody, but I guess it's nice. I mean, you probably should, because they would need to know that something has to happen. Someone has to do something afterwards, right? Someone has to go to the lawyer and be like, oh, I see a TOD's been filed. Someone needs to tell them they now own a house.
Yeah. You'd be surprised to say, I am currently not working. I need to get a will for my estate. Is one of the sites listed a good starting place um, to get started at a lower cost? Yes. Apply for Lone Star Legal Aid. And I'll send you the when this presentation is done, I will send a link to rewatch the recording and also our YouTube website or our YouTube channel to go to so you can watch it in either location. In addition to that, all of the documents or the templates that she went over for each one of those documents, I will include in the email as well. So in case you wanted to kind of start drafting your own, there's like instructions on there, what needs to go and what blank and things like that. However, remember she said about the fill in the blank document. So you make sure that all of the documents are like you copy and then paste to create brand new documents. You can't just fill your name in a blank kind of thing or whatever. So all in all, I see it still say apply for the services to see if you can get an attorney, if you qualify to have an attorney to review that and to do those documents for you. So the next session, which will be part 2 for Jesse, will be, this is February, March, in April, will be how to draft your will and a transfer on death deed. So you guys might want to come back and kind of review, and she'll tell you everything that needs to go in the will and how to get it properly executed and what to say and so on and so forth. Okay, thank you, Lisa. Okay, so for everybody that did register, I do believe I have your email addresses and it will go out to everybody. Um, let's see. In addition to that, Neighborhood Recovery, we will be also hosting a transfer on death deed clinic on Wednesday, March the 11th, kind of going over in detail about a Todd and executing each of those pages. And then you will have the opportunity as well to attend the actual Todd clinic on that Saturday, the 21st, where you can have an attorney to come in and to review your Todd for you and get it notarized and potentially get it filed for you also at no cost. So all of that information is on our website, as well as I will be emailing that information to you as well. So I will also be emailing out the schedule for our remaining a month of service presentations. Again, next Thursday, we have the inherited property and probate concerns presentation on Thursday. Let's see, that's all we've got. If you guys know or are aware of any renters, and they may be potentially facing evictions, we have an eviction presentation that's also done by Lone Star Legal Aid, as well as foreclosure prevention as it relates to HOA. That's the 4th Thursday of the month. Property taxes is one of the presentations about valuations and exemptions. The property tax bill was due on the 30th of January. So if you guys were not able to get your property taxes paid, what that looks like, when do they start foreclosure proceedings and things like that as it relates to your property taxes, how do you qualify for payment arrangements and things of that nature. We will have that presentation on the 25th of this month. But all of that is also detailed on the calendar that I will send out to everybody. So if you do have any questions, if your family members have any questions, then please feel free to have them reach out to us, to any of our legal service, our partners, as part of the month of service with any questions that you may have. And I think those were all the questions that were in the chat, Jesse. And the ones that you already went over were the questions that some also emailed to me. But let me double check just to be on the safe side. You went over holographic will, the difference between the Todd and that. You went over power of attorney. Yeah. Now here's one. Can I still get a power of attorney when my spouse has had direct decline in mental health due to an abrupt system of physical disease?
I'm sorry, can you repeat that?
Can I still get a power of attorney when my husband has had a direct decline in his mental health due to an abrupt system of a physical disease?
Um,
When
can the
can you get a
husband get
power of
one?
attorney? Hmm?
I mean, I don't know. So I mean, I don't know. She's asking if her husband can get one or she can.
No,
I
if
mean,
she can get one for her husband, if can one still be created if he's already kind of had a decline in his mental capacity?
I don't know because I don't know what's going on, right? So the thing is that like the issue with like capacity is that like, right, it depends on the capacity, right? Because I don't know what kind of mental capacity he actually has. So it's gonna have to be she's gonna have to go talk to an attorney. She has like the well, he has to go talk to an attorney, like, right, because he's the one who has to sign it and provide the power, and whether or not he has the capacity to do that is a different question, and I do not know the answer to that question.
It depends. The attorney.
It depends. It depends on whether or not he has the capacity. And I am not a I am I am not the person who can answer that question, unfortunately.
Okay.
So
Uh,
so but has a kind of a broad spectrum answer, right? Like lawyers debate this, like right there are sessions that that I go to and people talk about like when are people incapacitated to the stage that they cannot do it, right? It becomes a question of what do they understand what's happening, and do they actually have an understanding of what's going on, and things along that line. People can be diagnosed with an illness that is a mental illness and still have capacity to sign documents. It's a diagnosis in and of itself does not mean that they do not have capacity. It does just depend on where they are in their illness and whether or not they have it. And that is an individual situation.
okay. Uh, for the lady that put her, and I don't want to call your name out, the email address in the chat, I do have your email, so you will be receiving a copy of the recording and along with those documents. So you're good. Okay. I think that's about it. We are after 3 o'clock today, so thank you all for joining us this afternoon. There will be a link for a brief survey that pops up on the screen. So we ask you guys just to take a couple of minutes and give us a review or some feedback on the presentation that you all got today. If it was helpful, if it was beneficial, let us know so that we can kind of plan accordingly. But we want to thank you guys for joining us this afternoon. We hope you all have a wonderful remainder of your day. You all take care of yourselves, you stay safe, and we will see y'all next time.